It's Conduit News Radio with Paul Harrell.
Back to the program. Thanks so much for being with us on this Wednesday. Good morning to you. This is kind of the home stretch before we end the program. And I want to welcome, we have Annabelle Imber. She is a former Arkansas Supreme Court Justice. Welcome, Annabelle, to the program.
Thank you, and thank you for having me at this bright, early hour in the morning.
It's exactly right. I mean, it is, but this is where we like to do these segments because in the morning, because we get to kind of shape the narrative of the day.
Right.
And so this is, we want to talk about issue one. Now, you are in Northeast Arkansas for a couple of events. Let's go over those events first. You're going to be in Paragould around 2, is that correct?
Right. I'm doing a speech here in Jonesboro at 11:30, and then I'm going to Paragould for talking to the media as well, but then a meet and greet at 3:30 for anybody that wants to come. It's open. Yeah. I mean, that's what this is all about, is letting voters know what issue one is about, and then be back in Jonesboro at 5:30 for another meet and greet and fundraiser.
Wow, so three events. Now, you've got a sticker that says no on one. So
correct.
So your speech and you're going to be answering questions, basically, you're against issue one. I want to know why.
Sure. And part of the main reason, you remember, I'm retired. I don't have any dog in this hunt. Mm-hmm. But I am devoted to the issue of separation of powers between co-equal branches and checks and balances. I realize that the different branches can disagree with each other. Mm-hmm. That's what it's all about.
Yes.
But what is happening, and which I'm so concerned about, is this issue is called a tort reform amendment. But that covers up something underneath. It's kind of bait and switch. Everybody hates lawyers, right? So, those greedy lawyers, and that's the first part of the amendment. And then capping damages sounds kind of okay. I could go into the demerits of that too. But what I'm concerned about is what's not being talked about, which is giving the legislature the authority to make court rules of pleadings and practice. Now, if you know anything, and obviously, I'm a judicial creature. I've been in the law business over 40 years, and I am devoted to the issue of due process for everybody, whether they're wealthy, whether they're poor, no matter who they are, that they can go to the courthouse and get a hearing that is on equal ground, on a level playing field, just like on a ball field. And they know what the rules are. But the legislature making court rules, that process will be controlled, in my view, by special interests, people with the wherewithal to have lobbyists and try to tilt the scales of justice in their favor inside the courtroom, inside the process. Mm-hmm. Now, we have election of judges, okay? And that is political. But this will take it inside the process so that rules could be changed willy-nilly every legislative session. And all of a sudden you're in the middle of the ball game and the rules are changing just because somebody may have been unhappy about an earlier result. And right now it's done in a very open and transparent process. There are committees that include lawyers from every sector, meaning plaintiffs, defendants, lawyers. So everybody gets a say at the table. And these committees, appointed by the Supreme Court, review and deliberate. We've got lawyers from the law schools, professors. I mean, lawyers have to take courses in procedure. And you've got to have it work together so that if you change one thing, you might have an unintended consequence somewhere else. Now, I know this sounds all technical, but what happens is the recommendations of those committees go up to the Supreme Court. The Supreme Court, before it even considers it, issues the rules for public comment. They're put out in the public, and people, all kinds of people can say, okay, I don't like this because. And the court takes all those comments, considers them, decides whether to revise the rules based on comments or to adopt them, and then they're adopted. But the legislative process is very different.
Very different.
And basically, you only have 2 steps, which is file a shell bill, get enough sponsors, put it on a committee, rush it through, then get it to the floor. And so you're not having the deliberative process to know whether you are having unintended consequences and whether you're jimmying and rigging the system in terms of how courts operate, meaning how you can file a case, when you need to answer, what kind of evidence can be put in. All of these things, for example, class actions are for very small amounts of money, and they're basically for consumer fraud. I mean, if I've only been out $100, but I've been defrauded, what lawyer is going to take your case for $100?
Exactly.
So you have, but the argument is, those lawyers get all the money. Well, wait a minute. The point was not just for the recoupment of the $100. It's also to get the wrongdoer to stop doing that.
Yeah, that's exactly right.
Yeah.
Well, you had a huge lawsuit over the weekend, or it was talked about with Monsanto. I mean,
Right,
they may have had a chemical in the Roundup that they knew for years possibly caused cancer.
Mm-hmm.
And they've got to, and now they're going to have to pay, I think, $240 million.
Right. And here you are, of course, the capping of damages puts a limit per person, but it's on economic damages. So non-economic damages. So people say, well, what are non-economic damages? And of course, we're not really sure yet that,
Right.
but that would be anything like pain and suffering and scarring. I want to give you an example of a young woman in Wisconsin. They have tort reform. Their cap is $750 for non-economic, $750,000. Well, guess what? She went to the hospital. They didn't find that she had an infection. Because of that malpractice, she lost both arms and both legs.
Wow.
Now, the jury obviously gave her a lot more money for pain and suffering, but it was reduced to a lifetime for $750,000.
Wow. Yeah. So there's a lot of stuff that's
Going
jam-packed.
on.
And some of the potential challenges, I know they're saying it's eventually going to wind up in the Supreme Court as to whether or not, because you've got so many different issues.
Right.
Now, I've been covering the legislature for a little while, and they have a committee called the Special Language Committee.
Right.
And that's where you really have the slip-ins. And you talk about a lack of debate. There's no question in my mind that eventually, when they want to change the rules of evidence or set the rules of evidence for a case or whatever, it's going to be done, it's going to be slipped in somewhere. That's just the way they operate.
Well, and let me say this, in fairness to the legislators, when you're in a session, 60 days, you've got so many bills coming your way. And so how are you going to read all this stuff?
Yep.
Really due diligence. How are you going to do all that? And especially with something detailed like this. And so what you do is you rely on other people.
Yep.
You say, well, it's your bill. What do you think? Should I be for it? I mean, that happens all the time.
Yeah, it does.
And I'm not trying to be critical. I'm just saying the reality is that many, and of course with the term limits that will be on the ballot as well, this also is kind of the same protocol. Call it tort reform, but really underneath it is the poison pill. Call it ethics, but underneath it, we extended our term limits.
Yeah.
Call it something else, and by the way, the legislature took over executive rulemaking.
Yeah.
So I'm really concerned about the separation of the checks and balances between 3 co-equal branches of government, which is a basic pillar of not only federal government, but state government.
I find it interesting how you have some people who are for issue 1, and they claim that this will end special interests influence somehow. And what they're really talking about is they're trying to talk about the trial lawyers. But this whole thing was written by nursing homes or nursing home law. Now, and this is in the wake. And I want to get we're talking with former Supreme Court Justice Annabelle Imber Tuck. This was all done in the wake of a judge, Mike Maggio, pleading guilty to taking a bribe to lower a judgment. Then we have now Jake Files, who pled guilty to stealing taxpayer dollars, Senator Jake Files. We found it in discovery, in his in a lawsuit with the bank, that a nursing home lobbyist gave him $80,000, and yet he was the one that he had recently filed a quote tort reform bill. To say that issue 1 is going to solve special interest influence, it sounds like it's doing the complete opposite of that.
It will do the complete opposite, because when you have the combination of term limits and you have the combination of what you need at the legislature, because you've been there, you have to be there all the time, because you never know when a committee is going to meet, when something's going to be brought up for a vote. So who can afford to have a lobbyist? It's people with special interest groups.
Yeah, that already have a ton of money.
Right. And so I'm sitting there going, how does a regular person make an impact through that process on rulemaking? And I know this is something that may not sound sexy, but candidly, it's the foundation of the way we have, James Madison said, we can't assume good people. We have to assume everybody's going to act in their self-interest, and so you have to have this checks and balances. I'm not saying that people are evil-minded or anything, but let's just not be in fairyland.
Yeah.
Let's understand that we all come to things with different perspectives. And I have no problem. I can disagree, when I was on the bench, I'm not under the code of judicial conduct anymore, obviously. Otherwise, I wouldn't be doing a lot of as my friends call it, mouthing off. But I just couldn't say no when I was asked to head this effort. It was something where, because of this particular provision, and it wasn't going to be talked about, all of the ads are going to be about doctors and jobs.
Yeah.
Now, of course, I say to that, jobs, right? We have the lowest unemployment rate ever. We have a governor who has been bringing jobs to Arkansas without this amendment. We have a workforce that needs to be trained in 21st century skills, which our governor is trying to do with more vocational training. So what company is going to come here that needs those skills right now? Because we don't have them yet. We have the lowest unemployment rate. And then with doctors, to say that this small state with a tort reform provision will help us get doctors to rural areas, when, number one, the population in rural areas is decreasing, and doctors want, for their families, urban amenities. So I know board members of hospitals who try to recruit doctors.
Yeah.
Now, Jonesboro, it has a university, it has, other amenities, but we're talking about places like DeQueen or wherever. But what made the difference for Arkansas was Medicaid expansion. And I know that's a hot button issue, but let me tell you something.
$2 billion a year to insurance companies.
Right.
So.
But it kept rural hospitals open in Arkansas.
That is the claim. Yes.
Yeah. No, it did. I mean, there's studies been done where it showed how many hospitals closed in states around us that did not do Medicaid and had caps. And none closed in Arkansas.
So I would like to talk about the issue 1. One of the things I have a problem with would be the attorney capping attorneys' fees.
Well, and that whole issue of starting to control businesses, how they charge for their time.
Right.
That's, to me, a contractual issue.
Yeah, and get someone else to take your case. I mean, if who, if you can represent yourself, right?
Sure, you can. You have a constitutional right to.
You can, but I mean, not well. I mean, people are attorneys and professionals for a reason. If somebody told me I couldn't sell an advertisement for, as much money as I want to sell an advertisement for, that would be very totalitarian. You would think that would be, some sort of price control or anything.
Well,
I don't support that for attorneys.
It is price control, and what it does is effectively, because if you'll notice, it's 1/3 of net recovery.
Mm-hmm.
Well, what is a net recovery? Does it mean all of the bills, all the medicals, everything? What does that mean?
Mm-hmm.
And so you're basically saying to a lawyer, by the way, you're going to invest $200,000 in this with experts and depositions and all these things you have to do for one of these cases.
Yeah.
You're only going to get $150,000 out of it.
Yeah.
I mean, think about it. Lawyers are just like others. They're businesses.
Yeah, and they work for years sometimes without getting
and
anything.
they lose them.
Yeah.
And when they lose them, they get nothing.
Yeah, that's exactly right.
So
I got one question, though.
Sure.
As somebody who, was in the Supreme Court, is there such a thing as, is there a good tort reform? I mean, do you think there's any sort of tort reform that needs to take place? Obviously not this. I've been calling it the bad tort reform amendment, I'm not in support of it.
Yeah.
But what are your thoughts? Is there some sort of form of tort reform that'd be good?
Well, it's one of those issues, like they used to say, one of the Supreme Court justices of the United States used to say, it's all in the eye of the beholder.
Mm-hmm.
I am in favor of open courts. I believe in the jury system. A jury of your peers, and believe me, from my experience, we don't have excessive verdicts in Arkansas. In fact, we have conservative juries in Arkansas. And judges can already, you look at Maggio, can already reduce judgments based upon if the evidence doesn't support it or if the punitive damages are out of whack. Punitive damages are for correcting wrongdoers. It's not to give the money to the victim. It's to make somebody stop doing what they're doing.
Yeah.
So, it's hard for me as a person who has watched juries and how they operate. And then you have the appellate process, which protects you.
Mm-hmm.
Because if something's been done wrong at the trial level, then you go up and get it reversed.
Right.
As a legal error or something else. The jury may have been instructed improperly.
Mm-hmm.
I guess I get worried when we start saying, okay, somebody cannot go to the courthouse.
Right.
And, for example, some folks have filed a lawsuit to keep this off the ballot, this particular issue. And I'm not involved in that. But what I will tell you is I would fight for their right to go to the courthouse.
Right. We've been talking with Annabelle Imber. She's a former Arkansas Supreme Court justice. And that's pretty much all the time we have.
Thank you.
But I want to make sure you are in Northeast Arkansas today.
Correct.
If you can go over where you're going to be in the times one more time for everybody out there listening.
Okay. Well, I'm going to be in Jonesboro here for I'm doing a speech at the Kiwanis Club.
Okay.
And then I'm going up to Paragould, going to meet with the media. But then the meet and greet at 3:30 at the public library, their community room in Paragould from 3:30 to 4:30. And then I'll be back here at 5:30 at the Upper Crust Pizza.
Upper Crust Pizza. All right.
For a fundraiser, meet and greet. I just want to get the word out about what's in this that people are not talking about.
Yeah. If anything, get the discussion going, and so people make an informed decision. That's what you want.
And that's what I want. And let me tell you, if you want to come debate with me about it, I'm open to a debate. I'm open to debating anybody. That's what it's all about. Mm-hmm. It's about open dialogue, discussion, debate in the square.
Yeah. Well, I appreciate that, and I appreciate you coming on. It's
you,
great to
Paul.
meet you.
Well, it's wonderful to be here, and my father's people originally came from Paragould. I'm related to a bunch of Davises up at Paragould,
Okay,
so
okay.
they'll probably invade the meet and greet, and I'll have a few fans.
Yeah, you'll have some support there
Yeah.
for sure. Okay, well, Annabelle Imbertuck, I appreciate it so much, and
Thank you.
we got a long time between now and this election, so maybe we can do this again.
Oh, absolutely.
Yeah. Okay.
Absolutely. I'm, like I say, I'm doing on a volunteer basis. Our group only has one paid staff member.
Wow.
And what I want to tell you is what we're going to have against us is millions of dollars of media coverage beginning in the fall, very close, that will just say jobs and doctors.
Yeah.
Please, as you listen to that, be very skeptical.
Yeah, absolutely. Yeah. Candy corn, or unicorns, rainbows, utopia,
Well,
you know?
yeah, anything that is a soundbite, a buzzword, that sounds good, and
Yeah.
it's poll tested.
Right, that's exactly right. Poll tested. That would be kind of like propaganda. Folks, we're gonna take a break, and I really appreciate it, former Justice. Thank you so much for coming.
Thank you.
All righty, folks, got to go. Back in just a moment.